Okay, so now you're going into your CCE trial after already being convicted.
So I get denied on double jeopardy, and now I have the CCE trial.
Right. And the CCE, if you had blown trial, it'd be life?
Life on top of the 30.
Okay, so at what point do you start representing yourself? Which to me sounds crazy.
So I found, me and Tamer found, so when you have a wiretap in a case, it has something called a 10-day report. So they go to the judge, hey, we need to wiretap these guys for drugs. We're going to have, and the judge says, okay, and signs the order, 30, 60 days, whatever. But every 10 days, they got to make a 10-day report to that judge. How many calls were there on the line? How many of them were drug calls? How many of them were minimized? What is minimization? Minimization is if me and you are talking about mom's birthday, they're supposed to stop listening to the call. Not for any set period of time. It could be a second, could be a minute, could be 5 minutes, could be they don't pick up again on that call. Whatever, that's not the thing. But what they have to show is that there is an active monitor there who is doing their best to try to preserve the privacy that you're entitled to from the Constitution and that other people who are not part of the warrant are entitled to as well. So that's why you can only have one monitor listening to one call at a time, right? So you get this report, and that's happening before everybody turns rat, remember, right? Well, now you have a trial, and then no wiretaps in the first case. They said there was nothing relevant on wiretap. The wiretap comes in on the second case because they have Tamer's phone's wiretap, so it's hugely relevant for his CCE, right? And but if you compare, what I'd done already is I'd compared the wiretaps with the trial transcripts in the first case of the informants, and there was tons of lies. That actually, we can get back to that, but my sentencing for the 30 years was very key to that particular point. It's how I got back on appeal on that case. So anyway, then what we did is we counted, once we got the wiretap, we looked and we said, okay, how many calls are minimized? And then we compared that to the 10-day reports. And we saw that on 8 different days, a total of 21 more calls were minimized now on the wiretap itself than were minimized according to the 10-day reports. Well, Title III says you can't have equipment that can add, edit, alter, delete, or erase. Now, I can't prove, I know it's 8 different dates, and I know it's 21 total calls more minimized, but I can't tell you which ones were done legally and which ones were done illegally. But what I can tell you is there's minimization in the middle of drug conversation, which is absolutely not supposed to happen. So I've got like kind of a prima facie showing, right?
Got it.
So I go to the lawyers, Louis Palazzo, fucking horrible. And I tell him, and he's like, oh no, you know, there's no way the government doesn't tamper with. I was like, listen, I want to go after the government. I want to call the government as a witness under the best evidence rule. And I want them to be disqualified because they have a conflict of interest now, because I want to ask them point blank when they decided to tamper with a wiretap in order to secure a conviction against me. Lawyer doesn't want to do it, I fire him. You know, like we go to court, judge is like, what's up with the attorney-client relationship? And I was like, and I was kind of funny. I said, well, Your Honor, I'm here today because I'm willing to cooperate, actually. And everybody stopped, you know, and everybody looks, I was like, whatever diploma this guy is hanging in his office that's saying he passed the bar, graduated law school, must be fake, and I'm here to help you in that prosecution.
All right, so you're making jokes in the courtroom.
Yeah.
Got it.
So anyway, you know, the judge is like, well, Mr. Ziskin, you know, I was like, Your Honor, Feretta versus USA, I'm doing this of my own free will. I understand the charges against me, and I understand the consequences of a guilty verdict. I have to be able to represent myself. The Supreme Court's already dictated that.
Right, but you have a disadvantage representing yourself because there's certain things a lawyer could do that you can't do
like
when you're
what?
Representing. Someone broke it down to me. It's like,
see, I see
a lawyer could say, well, I'm not sure You'll have to, you know, this is what my client told me, and to the best of my ability, this is what I think. Whereas when you are actually in the courtroom, you're under oath and you have to answer yourself, right? I believe that's what it's about.
Well, no, no, no.
No?
You could still make arguments. I'm not making representations. I'm poking holes in the government's theory. The government's theory of the case has a problem if every time you make them change it, right? Because their story changes. And in fact, I see it as totally opposite, in the sense that lawyers are officers of the court and are bound by certain rules of decorum and procedure, whereas you as yourself are not. You can say shit. And not only that, when you're cross-examining a witness or examining a witness or talking to the jury, you're testifying without being cross-examined. You're able to build a relationship with those people, right? Like, so if you're smart, and most people, again, we're dealing with all people who got caught, so most people are not, right? They can do amazing things, but what they didn't do was get away with it. But if you're smart enough, then the benefits far exceed the drawbacks. Now, in most cases, it's true. The person who has himself for a client is a fucking idiot, right? Like, but in cases where you have the necessary gray matter to play this game, then I think the benefits, the advantages far outweigh the drawbacks. You're going to lose on procedure, but you're going to win on everything else.